Welcome to Business Innovators Radio, featuring industry influencers and trendsetters sharing proven strategies to help you build a better life right now.
Hi, this is Tammy Patzer, and I am very pleased to introduce you to our guest today, Mark Martella. Mark is an experienced authority in business law and business practices, real estate matters, foreclosure, and bankruptcy. In his 28 years as an attorney, both in New Jersey and Florida, he has helped thousands of clients facing business and personal financial challenges. He's written dozens of articles on these topics, and he recently published a book, Bankruptcy in Plain English, The Ultimate Layman's Guide to Taking the Fear and Mystery Out of the Bankruptcy Process. Welcome, Mark.
Thank you, Tammy.
I'm really excited to talk to you today because you have written quite a few educational reports, and one caught my eye, and it's the 7 biggest mistakes people make prior to filing bankruptcy and how to avoid them. And I know that many people, the word bankruptcy, the first thing that comes to mind is fear. And I think that you can probably address that. So if you would first tell us a little bit about how you ended up in Florida, maybe, and then let's dive right into mistake number 1.
Well, how I got into Florida was we came down to Southwest Florida on vacation at Sanibel Island, and that was in 2003, October 2003, and really fell in love with the area. I was tired of the rat race of working in Jersey City, and about 8 months later, we decided to move down and then closed on our house 4 days before Hurricane Charlie. So that was a welcome, unwelcome greeting to Florida, but we've been here since 2004 and really love living here in Southwest Florida. And I've now practicing here since then. And the reason I came up with this special report as well as other special reports is to try to educate people. Like you said, people are afraid of bankruptcy. They're embarrassed. And they don't seek the information. It's very similar to having a toothache. You know you have a toothache. You know you should go to the dentist, but you're afraid to go. And the longer you wait, it gets worse, from a cavity to a root canal. Same thing with the bankruptcy and financial issues. People know they need help. They can't get out from under this debt, but due to A, just not understanding what bankruptcy is, and B, all the misconceptions out there about what bankruptcy is and how it ruins them forever, prevents them from seeking the help they need. So what I try to do is come up with these type of special reports that people can get for free on my website. They can read it in the privacy of their home to begin that education process, to get them past their fears. And what we're going to talk about is to avoid common mistakes that I see people make before they come and see me. We have a sign in one of our offices that says, "You can't unscramble eggs." And so many times people have come to see me, they've already made a mistake, and there's nothing I can do to fix it. Whereas had they come to me earlier, we can avoid a lot of these problems. And that leads me into, the first big mistake I see is using exempt funds from, say, a retirement account like a 401k or an IRA to pay off credit cards. If you properly set up an IRA or 401k, those assets are exempt from creditors. So if you have a $100,000 401k and you have $60,000 in credit card debt, you can file bankruptcy, discharge that debt, and keep your $100,000. A lot of times, especially here in Southwest Florida, where we have a lot of seniors, if they use up all those funds, or worse, what they've usually done is take out a little at a time. So it's that boiling frog scenario where they think things are going to get better, and they use up all of their retirement funds, and then they come to see me. Whereas had they come to see me earlier, I could have explained things. They would file bankruptcy, have that debt discharged, and then be able to live on because they have that nest egg that they worked for such a long time. And again, part of it comes down to the embarrassment of it. They're afraid of what will their friends think, what will their family think, what will their church think, when the reality is everybody knows somebody who has filed bankruptcy, and it doesn't have the stigma that it once was. So that's the first big mistake that I see.
Wow, I was just thinking about that because I think that is something that most people probably don't know, that their retirement funds are protected and that they don't need to drain their retirement funds to pay off their credit card debt. So I think that's a really good piece of information. So what's mistake number 2?
Well, mistake number 2 is particularly important here in Florida, but it also would apply in other states throughout the country. But here in Florida, one of the best exemptions that we have is your homestead. The equity in it is exempt, meaning that somebody could have, again, a $500,000 judgment against you if it's for credit card, a car accident, medical bills. If you have a homestead, and whatever equity that you have in it, whether it's $1,000 or $100,000, that is protected from creditors. And other states have varying degrees of that. Some don't, but most have some form of that. So what I will also see is people say, well, I have some equity. Let me take out a second mortgage, pay off my credit cards, and have a lower payment. I'm not paying the exorbitant interest rates. I'll pay a more reasonable interest rate. But the problem is, if they do that, they've taken a non-exempt asset and now made it subject to the bank because the bank now has a lien. And if they can't make that second mortgage payment because they really didn't look at the reality of the situation, that by doing this refinance, so to speak, they're just putting a Band-Aid on the problem. Now they've exposed their house to a possible foreclosure when that was protected. So it is a very serious mistake to make. I see it a lot in situations where there's a small business because a small business is trying to stay alive, so they're going to tap into whatever asset they have. So their business winds up closing up. They can file bankruptcy on their business, but they now subjected their home to debt related to the business that is secured, and we can't discharge a secured debt in bankruptcy. So that is a huge, huge mistake, especially for small business owners.
So can you clarify just a couple things, because this is for me. You said that a credit card is an unsecured debt typically, but your home, if you go get a second mortgage, then of course that debt is secured. And can you repeat how that affects the bankruptcy situation?
Sure. So let's take the credit cards, for example. They are treated as an unsecured debt, meaning that card does not have a lien on any property. So when we file bankruptcy, that debt is discharged. But if you decided to pay off that debt by taking out a mortgage on your home, so if you had a $10,000 credit card, you take out a $10,000 loan on your house secured by a mortgage on your house, and you can't make the $10,000 payment because it's secured by your house, a secured creditor in bankruptcy has to be paid in full. If they're not paid, and there's options to pay that, but if they are not paid, you will lose your house. They will be able to file what's called a motion for relief from the automatic stay, and the automatic stay is one of the most powerful benefits of bankruptcy, and that once you file for bankruptcy, it stops all creditors from pursuing you. However, the exception is a secured creditor. So if you can't make those payments, whether it's a car loan or a house loan, the creditor then has the right to continue a foreclosure action or continue repossession of a vehicle. So that's the main difference between a secured creditor and an unsecured creditor.
Wow. So what I'm hearing is, if you're even contemplating bankruptcy, you really need to talk to a bankruptcy attorney to get all the little details and the facts straight, because little things like that are things, like you said, I think that people trip up on because they just don't know how the laws work. What's mistake number 3?
Well, the third mistake is going on this theme of trying to pay debt off from other means. And the other thing that we see a lot is, hey, look, you're a little behind, you need help. Who do you turn to? You turn to your family, you turn to your friends. And again, it's the same issue in that 9 times out of 10, it's just a Band-Aid. So you borrow $10,000 from your parents to try to pay off your credit cards. But it doesn't fix the big picture because you have other issues, and 6 months later, it turns out you're still filing bankruptcy. You don't have the ability to pay back your parents, so your parents lost $10,000 that they may have taken out of a retirement fund, and you've wasted that money. And so often I meet with the parents who have lost their savings or have put a second mortgage on their house to help their children out when their children promised to help them pay the second mortgage back, and it turns out they're losing everything too. So it can get compounded. So that's that one problem with borrowing from friends or families, that the likelihood, in my experience, is they're not going to get paid back. But let's say we have an example. You're getting a tax refund of $5,000. So you go to your dad and say, Dad, I need $5,000 to pay off these bills. As soon as I get my tax refund, I'll give you back the $5,000. And you do that. You pay off the credit card, you get your tax refund, you give it back to your dad, and then 6 months later, it turns out you still have to file bankruptcy. Well, that's still a problem, because even though you borrowed the money, you paid back your dad is treated as an insider. Any friends, family, or business partners are insiders, and any payments made to an insider within a year of filing is considered a preferential payment. And what happens is the trustee will knock on their door and say, give me back that $5,000. Because again, your dad, who just loaned you $5,000, is an unsecured creditor. He cannot be treated any differently than MasterCard or Visa. So the trustee will get that $5,000 back and then spread that $5,000 out over all of your creditors. So, again, that's another mistake that we see quite often, which is quite natural, but then it causes greater problems once we file and the trustee starts looking at these transactions that happened within the first 12 months.
Wow, I didn't know that, because the way you described it, it sounded just like, hey, I need $5,000. I'll pay you back as soon as I get the tax refund. So you do it, and then, of course, it comes back to bite your family member because you just didn't know the way things worked. That's a really good piece of information. You also talk about people who they think they need to pay off their car, and so they dig into ways to do that, and that's mistake number 4. Can you talk about that?
Right, and again, this is where we're using common sense, things that make sense to someone who's not familiar with bankruptcy. But then when we go into the bankruptcy arena, it causes big problems. Typical situation. So you're struggling making your payments, but you figure, hey, if I can get rid of this $300 car payment by paying off my car loan, I can make ends meet. So you take out the $10,000 that you owe on the car. You take it out of your 401k. First of all, that's very expensive money because you're going to be paying penalties on it. But you take that $10,000 and you pay off the car. And the car was only worth $10,000. So now you have a $10,000 asset. And the problem is, in bankruptcy, each state is a little different, but I'll talk, for example, in Florida. In Florida, you get to exempt $1,000 of equity in a vehicle. So if you have a $10,000 car that has a $10,000 loan on it, it's worth $0 for purposes of your assets in bankruptcy. If you have a $10,000 car that you just paid off the loan on, now you have a $9,000 asset, of which, after you deduct your $1,000 exemption, that in a Chapter 7 bankruptcy, either you have to turn over another $9,000 if you want to keep it, or you have to give the car to the trustee. So it is a horrible mistake, but we see it quite often. In reality, you want secured debt on your vehicle when you file. The best case scenario in a bankruptcy is to have a leased vehicle because that's not your asset. So that is a big mistake we see quite often. People trying to make ends meet, thinking they're doing something that's good for them on a monthly budgetary basis, but from a bankruptcy standpoint, it's a nightmare.
Wow. So in this case scenario, having a leased vehicle is better because you're literally renting it, so it isn't considered an asset. And what about people who have like a car that's like 10 years old? Is there a limit, or do they just look at what Kelley Blue Book? How do they determine how much these vehicles are worth in terms of being an asset?
Well, basically the trustees here in our district will use the NADA value, and it's what you're valuing your property. It's what it would cost to replace a similar item of similar age and similar condition. And unfortunately, the NADA values are generally the highest values. So the person filing has the burden of proof. And what we do for our clients is we will have them get an appraisal done of the vehicle. This way we have the proof, since we have the burden of proof, and the trustees will accept the appraiser that we use. So that's how we set the amount. And this way we know going into the bankruptcy what we have that is non-exempt that we may have to buy back, or if there's nothing that's exempt. But that's where it comes down to doing your homework beforehand. We like to know everything that we can anticipate going forward prior to filing, so we can plan accordingly.
Wow, the more you talk, the more I just think, wow, if you're ever contemplating bankruptcy, you really have to go in and talk to somebody with all these little nuances of all these little teeny details that smart people, and I consider myself pretty smart, I would never even think of any of this, because in our daily lives, we just, we have our cars and we have our work and we pay our bills, and then, it could happen that one day we find out, oh my God, I'm so far behind, I need help. And you really need to talk to somebody who's knowledgeable. Mistake number 5, I think, is interesting. You have the title is Failure to Advise Your Elderly Parents of Your Financial Situation. And I can imagine your parents or anyone's parents, you would be so embarrassed. And that's a big mistake, not to tell these people why.
Exactly. It's human nature. You don't want to share your financial difficulties, especially your parents. You may have been saying everything is fine. You don't want to worry them. But if your parents have some means, it could be simply having a house that they want to leave to you, and you would inherit that. Even within 6 months of filing. So anything that somebody inherits within 6 months of filing of bankruptcy becomes an asset that now is the trustee's property. So what can happen is, and look, best laid plans, you can't fix everything. Often it'll happen with a relative. We recently had a case where we filed bankruptcy. It was a Chapter 7. Clients received their discharge, but within 6 months of filing, an aunt passed away and left them $45,000. Well, that was almost as much as all the debt they had, and they lost probably about 80% of that had to be turned over to the trustee. How the trustee finds out about it is you have to turn over your tax returns. So what we recommend is in our interviews with our clients, we'll ask about, do you expect to inherit anything? If someone has already died, even if they filed bankruptcy, even though you may not have received it, upon somebody's death, title to that potential inheritance is considered already yours, even though all the paperwork wasn't done. So we would much rather see, whether it's a CD or a house or a car or a boat or whatever that item is, much rather see it go to a brother or a sister or even a charity than see a Visa or MasterCard get it. So, and it only has to be for a short time. I mean, the parents would have to, if they already have a will, they can do a codicil, changing things so that the person who's filing bankruptcy is not not a beneficiary. And then once 6 months have passed, they can put everything back. But it's just a shame on those occasions where, and it happens more often than you think, where someone passes away and we have a client that inherits something that they're going to lose. So it's a difficult conversation to have, but it's an important one to have as well. And it goes both ways. It's not just telling parents, it's parents talking to children. So often I'll meet with an elderly couple who are brought in by their kids who lived up north, as we say here in Florida, and the kids will say to me, we thought they were okay. They had a 401k. We thought everything was fine, and we learned that they have nothing but their Social Security. So it's having that difficult conversation from a parent having to tell a child, which may be even a harder conversation to have. But when it comes to these type of finances and financial difficulty, it's so important to discuss this with your family members.
Wow. So have a conversation, even if it's difficult, because if somebody wants to leave you something, it may just be the wrong time, and then it would end up, like you said, going to pay off all your debt, and you wouldn't benefit from it at all, when it
Correct.
could have benefited someone else. Mistake number 6 is very interesting because it's related to short sales, and as most people know, there have been many, many people who have had issues with foreclosures or short sales or their homes because of the failure of the economy, and I think we're now coming out of it. But talk about mistake number 6 and how a short sale could affect a bankruptcy.
Well, when you short sell a piece of property, what that means is that you're selling it for less than what you owe on the property. As a result, that debt that is forgiven is treated as taxable income to you. And generally, except in rare circumstances, we can't discharge that tax liability. So if you sold a piece of property, especially if it was a commercial piece of property, not your residence, and you incurred tax liability, while you have been relieved from a deficiency, and that's why they, or you may have been relieved from a deficiency, that's why you would receive the 1099 showing this income if you ultimately still have to file bankruptcy because of your credit card debt, now you've incurred a tax liability that we can't discharge. So it really comes into taking planning. Quite often we're seeing people for foreclosure who ultimately will have to file bankruptcy. And there's no real benefit to doing a short sale because you're going to discharge any liability you will have if the house is worth less than what you owe on it. So you're better off filing your bankruptcy before doing a short sale, and then you can still sell the property, and you don't have to worry about any potential tax liability because one of the rules under the bankruptcy code is any debt forgiven, whether it relates to a mortgage or relates to to credit cards, is not a taxable event. And keep in mind, while mistake number 6 applies to short sales, it also applies to credit cards. As you cut deal with your credit cards to pay them off for less, you will incur tax liability. So if you have 10 credit cards, you settle with 2, but you still have to file because you have 8 credit cards. It was a waste of money, and you've incurred tax liability that relates to those 2 credit cards. So you really need to have a whole master plan on how to go forward. Now, there's one caveat with this, and it relates to your personal residence. If at the time of the short sale you sell your personal residence, it's not a taxable event. However, for the past 2 years, that law has expired, but Congress has extended it. So they've extended it through 2016. So as long as it's your primary residence at the time of the short sale, that's another way to avoid that tax liability. But if it was an investment property, or so often people have already moved out. So if you're not living there, that exception doesn't apply, and you would incur that tax liability.
Again, the more I listen to you, the more that I can certainly, I understand that you really have to go to talk to a professional who knows all the ins and outs of this. Mistake number 7, it actually brings us to that, which is individuals who are trying to represent themselves in bankruptcy. So talk about why that is probably not a good idea. My common sense is telling me that is not a good idea and that you really need to talk to a professional, but I'll let you explain why you really need to talk to somebody.
Well, and basically, you've heard 6 reasons why you should go to a professional. But the biggest thing is one of the parts of the bankruptcy process is you have to go to a creditors meeting where you go and you answer questions of the trustee. And I can't tell you how many times I am there where someone is representing themselves, and I hear the questions that the trustee is asking, and I know that they are just burying themselves. They're thinking that they're doing everything okay. And the perfect example is one that I gave you earlier. The trustee will ask, have you paid back any friends or relatives any money in the last 12 months? And they'll say, oh, yeah, I paid back my dad $5,000. And they'll say, when exactly was that? I did that 3 months before I filed bankruptcy. And so the trustee will ask, well, what's your dad's address and phone number? And they give that address and phone number. Trustee doesn't say anything more. But I know that dad's going to get a letter saying, hey, you have to give me that money. So all these type of things. I mean, look, quite often we come across that situation, but if somebody comes to me and they said, well, 9 months ago I paid back my dad money, I will say to them, okay, we have to wait another 3 months so that you're out of that 12-month window, and then we don't even have to disclose it. So just, a timing issue can be very costly. And then I can give you 100 different examples of those type of things, people saying things, not realizing they need to have appraisals of their personal property or of their automobiles, and how generally, depending upon the car, of course, but we can save a client a couple of $1,000s on appraisal by just spending $75, whereas if they haven't done that, they'll be paying out another $2,000-$3,000 to the trustee just because they didn't know that. So, I like to tell people you can learn how to do an appendectomy online, but I don't suggest you do it on yourself. And the same thing with bankruptcy. And I would point out that the vast majority of attorneys don't even touch bankruptcy because it is so unique and so statutorily based. And even myself and most bankruptcy attorneys, they totally revamped the law in 2005. So it was almost like going from playing under the rules of a baseball game to being switched to a football game, because so many things changed, and there are many unanswered questions still out there that there's differences of opinion on. So it is a constantly changing area of the law. We constantly go to seminars and follow the case decisions as they come out all over the country, and it's just something that I really recommend somebody getting advice and not going it alone.
Well, as you've heard me exclaim several times throughout the interview, I absolutely agree that you have to talk to a professional. And with that said, how can people find out how to get in touch with you so that they could meet with you? And I know that you have 2 offices in the area, so talk about how they can contact you.
Well, the easiest way is to call my Port Charlotte office at 941-206-3700. And we offer a complimentary 1-hour consultation to go over your financial situation. Also, we've been talking about these 7 mistakes. If someone would like to get this free special report in writing, they can simply go to my bankruptcy website. It's called Martella Bankruptcy, all one word, .com. You can go there and instantly download the special report. Or, if you'd like, you can request a free copy of my book, Bankruptcy in Plain English, where we go into more depth in these 7 mistakes as well as other areas and explain the whole bankruptcy process to you. And that's complimentary. Also, on the Martella Bankruptcy website are 7 videos where I'll go into more detail about the bankruptcy process as well. Again, it's my goal to try to get as much information out there to stop these things before people come to see us, educate them to get past their fear and learn how, look, we can get rid of your debt put you on the road to a fresh start. Yes, you can get a car again. Yes, you'll be able to buy a house again. Yes, you'll be able to get credit cards again. And it's not the disasters that the credit card companies and the banks want you to think it is.
Well, that I like ending on that hopeful note that even if you do have to go the route of bankruptcy, that there is life after bankruptcy. Mark, I really appreciate the time you took to talk to me today. I really appreciate it. Thank you.
Thank you so much.
This is Tammy Patzer. Go make it a great day.
Thanks for listening to Business Innovators Radio. To hear all episodes featuring leading industry influencers and trendsetters, visit us online at businessinnovatorsradio.com today.